Welcome to the NREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Hey, everybody. Welcome to the show. Today, our topic is the best practices to secure your transaction. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, or if you're old to the show, either way, give us a like. Make sure to subscribe to the channel. That helps us get you content, and we would really appreciate that. With that, we're going to go to Sean. If you could give us our legal update.
Sure. Thanks, Andy. So today I want to talk about deeds in lieu of foreclosure. Who knows what the market's going to do, if there's going to be a shift. But if there is, then we might start seeing, some more foreclosures. And one of the topics that comes up during that time is deeds in lieu of foreclosure. What is a deed in lieu of foreclosure? A lot of people don't even know or appreciate or understand what that is. And a lot of people don't understand the pitfalls that are associated with deeds in lieu of foreclosure. So what a deed in lieu of foreclosure is just what it sounds. It's a deed that you provide to a lender in exchange for the lender agreeing not to foreclose on you. That's basically it. So the lender's going to foreclose, there's been a breach of the loan documents, a failure to pay, whatever the case may be. And the lender is heading down the foreclosure path. And then you and the lender come to some form of agreement and you say, okay, don't foreclose on me. I'm going to hand over to you a deed to the property in lieu of foreclosure. Now, what does that mean from the lender's perspective? So a lot of our clients are investors. Some of them do seller carryback transactions. Some of them provide hard money loans. And so from the lender's perspective, what is a deed in lieu of foreclosure? What does it mean to them? Meaning, what's the difference between receiving a deed in lieu of foreclosure and foreclosing? Because it seems like if I'm the lender, and in Arizona anyway, I have to wait a minimum of 90 days to complete my foreclosure from the date that I start it, versus I could receive a deed in lieu of foreclosure in a matter of weeks.
Right. If you're the lender, it sounds cheap and fast.
Right. It sounds cheap and fast, but there's pitfalls associated with that, because by taking a deed in lieu of foreclosure, you're going around the statutory foreclosure scheme. And the statutory foreclosure scheme states that if you're the lender and your mortgage or deed of trust is recorded on a certain date, then anything that comes after that date, you're ahead of, and you take priority over. So if you go through the process and you give the right notices to those inferior interest holders, and you notify them of your foreclosure, and you do everything the statutes require, and then you complete that foreclosure, you wipe those interests off the property, and you're ahead of them. You now take the property without being encumbered or clouded by those interests on the title. Well, a deed in lieu of foreclosure does not work that way. So a deed in lieu of foreclosure means you're doing an end run around the statutes, and you're taking title, and the date that your interest vests in at that point is the date that you record that deed in lieu of foreclosure, that deed that you're given in exchange for not going to foreclosure. Well, now anything that is recorded against the property, you're taking subject to that, even if those interests were recorded after the date of your mortgage or deed of trust. So you have to be very careful from a lender's perspective to run a title report, and maybe even I recommend obtaining a policy of title insurance for that conveyance to make sure that you are in fact protected. And that's something that could be negotiated with as far as the borrower goes, is maybe, putting in there, like, we're not going to foreclose on you, but you're going to pay for a policy of title insurance because we want to make sure that we're protected. And have the borrower pay those funds and provide that policy to you as a lender to make sure that you're protected and you don't have any title issues. Now, I've seen situations where um, deed in lieu of foreclosures were done without researching title to the property, and the lender just assumed, well, I'm getting a deed in lieu of foreclosure, everything should be fine. And then all of a sudden now you have, the homeowner or the borrower went and obtained a second position or a third position lien, and all of a sudden you're strapped with that. It's a major issue. So it's something to be very careful with and not something to take lightly. You want to make sure that any offer for a deed in lieu of foreclosure from a lender's perspective is going to be conditioned upon you receiving clear title and having the ability to obtain a policy of title insurance as to that particular deed.
Yeah, I've never really understood. I mean, I understand the strategy, why it can be faster, why it can be beneficial in certain circumstances, but when you think about how much money you're really saving to begin with, I know it might vary from state to state and the process might be long, but here in Arizona, it's a relatively short period to foreclose, 90 days from the date of the notice of trustee sale. If you're doing a trustee sale, you've already probably paid for a trustee sale guarantee. So you already know the condition of the property. And what I've tried to explain to clients is, look, this is like a cleansing of title by doing this foreclosure process. Do you want your title to be just as clean as the law can provide it? Then go forward with this. You're really not missing a whole heck of a lot of time, but I think the lesson here is if you're gonna go that route, be really careful, right?
Right. And even in Arizona, to highlight what you were stating about the cost involved, yes, you have your trustee sale guarantee, which is title insurance, right?
Right.
It's something that the trustee obtains to make sure that they're protecting themselves and that they're sending out the proper and correct notices. But also, our trustees' fees are capped in Arizona. It's basically the greater of $500 or 1/2 of 1% of the then existing principal balance. So unless you're talking a huge loan, it's not that expensive to do a trustee sale here in Arizona, because either way, whether you do the trustee sale or a deed in lieu of foreclosure, you're probably going to want a title policy and you're going to have to pay for that. So why not just pay the extra to do the trustee sale? And like you said, do a cleansing of title through that sale.
Yeah, have security under the law that what you're getting is what you had hoped indeed to get. All right, with that, we're gonna get into our topic today, which is really talking about the best practices of securing your transaction. And to give some context to this, when we talk about securing your transaction, if you've loaned money, you've loaned money with the expectation of being paid back, but that isn't worth a whole lot. And in real estate, it can be customary, as well as in areas outside of real estate, to ensure that you get some additional collateral in order to protect your loan. The problem is when that's not done correctly, the problems that creates or can create in the closing process. So, really, our topic here today is to discuss those best practices in securing your transaction and issues you can find, or dealing with problems that can arise in escrow because that hasn't been properly done.
Well, even, you know, taking it a step further from the loan transaction to just the purchase, right? You enter into a purchase contract with someone and you expect to be able to close. But if your contract is missing maybe certain terms that provide for the protection of maybe the buyer, or even the protection of the seller, you might not be able to close. And there, either side may have an ability to exit, or you just may create complications to the closing that make it difficult to close, and then maybe the parties just decide to walk away or something like that at that point.
Sure. And so with us today to discuss these issues and others, we have Erika Weichel, president of Michigan Investment Title. Uh, she's gracious enough to join us here today to discuss these issues. Erica, so much for being with us.
Well, thank you for the invite. I appreciate it.
Yeah, so tell us a little bit about Michigan Investment Title.
Well, I'm been in title for 25 years. I've worked for other title companies. I've worked for the underwriter for several years. I started investing in real estate myself and started joining some investor groups and found a need for investors and someone that understands what they're trying to do with title. So from that, I had a transaction coordination company, and then I grew my actual title company based on my investor clientele. So
So
I'm really investor focused and friendly.
when you talk about the coordinator company, is that the My Coordinator LLC?
It is.
So
It is.
tell us just a little bit about that.
So, when I started going to these investor meetings, a lot of local RIAs, people found out I was in title, so they were coming to me and asking for help. And because of my connections through title before, I was able to contract with certain title companies as their rep, and I would advertise myself to investors as a free coordination services because the title company would pay me. So it worked out really well. I got to know a lot of great investors and coordinated most of their transactions.
So you have experience and are used to, it sounds like a lot of experience working specifically with real estate investors. Um, our topic today is best practices in securing transactions, and really what we're interested in here is when those deals create problems to close, and fixing closing problems or problems at closing are never more in front of anybody more than maybe escrow officers and title agents. But what are common contract problems, or maybe the most common problems that you run into in dealing with closing transactions?
So in Michigan, we are not a title attorney state. So I'm not an attorney. So we are not allowed to really interpret their purchase agreements to start with. So I always recommend that everybody have an attorney go through their documents, especially the investors, to protect them. Especially they forget certain things or they leave things that are so vague in their contract that it could go a multitude of ways, which if you get to the closing table and these aren't conveyed properly, we're redoing docs and they're renegotiating right at the table and sometimes walking away. So, I mean, things as in when you say the buyer's going to pay all closing costs. Well, does that mean the title insurance as well? Does that mean the transfer tax and the recording fees? They're just, you have to be very clear on what your contract is stating. The buyer thinks one thing, the seller thinks another, and get to the table and we have issues. So just clarity for sure. EMDs, how to get your EMD back. If it's going to go to the buyer or the seller is another one. Um, it helps tremendously if people, when they do like inspection, instead of saying 5 days, if they put a date, because 5 days is that including the date of the contract that maybe the buyer signed one day, the seller signed another day. So it's leaving so much play for interpretation in their contracts. That is definitely, a stumbling block and something that takes time to work through when there's questions.
Erica, I wanted to go saying about the closing costs, because a lot of the contracts that I receive and review, it has just that generic language, that they put in as an added term, buyer to pay all closing costs, right?
Yeah.
And I think for the most part, a seller's not going to have any issues if the buyer steps up and pays all closing costs, right? But traditionally the seller pays for the title insurance policy, which, like you said, is not a closing cost. So what are those things that should be specifically spelled out from a title perspective on a purchase contract and identified as to what the buyer is going to pay and what the seller is going to pay?
So it's funny, a lot of my clients, I had an attorney prepare an investor-friendly purchase agreement. And on it, it's two little columns on there, and it says buyer pays, seller pays, and there's little marks. So something like closing costs, transfer tax, recording fees, owner's policy. And it's just to be specific so everybody knows what they're actually going to be paying for up front. And then there's no questions when it comes across my desk or my processor's desk to get it done into the closing table.
In Arizona, we have a lot of these. I don't know if you have them in Michigan, but HOAs.
Yes.
And there's a lot of fights that I see on, closing or settlement statements if you're not specific in your contract as to who pays what related to the HOA, because there's 3 or 4 different fees, all called different thing: a reserve fee, a disclosure fee, past due assessments, future assessments, the list goes on.
A transfer fee.
Yeah, transfer fee, right?
Yeah.
Talk to us a little bit about HOAs and what kind of things they make the transaction go smoother as far as language regarding HOAs in a purchase contract.
Yeah, so generally it states in there, in Michigan anyway, that the seller is going to pay for a status letter from the HOA, any due assessments, especially if there's any big assessments that are due, if they're redoing the roofs or something like that, and all the units were assessed a $5,000 or $8,000 or $10,000 assessment. It says that the seller is going to pay that in full. So sometimes that gets a little sticky when there's a big assessment due. But generally, just that the dues are prorated. Buyer will pay the transfer fees. Seller will pay for the status letter and any past due assessments.
This is a little bit off topic, but I'm just curious if Michigan's the same and kind of how you guys deal with it. But one of the things that we see here in Arizona, and it really is dictated by how our statutes read. So our statutes basically state that your regular or special assessments, the amounts that are charged to every homeowner, those are liens against the real estate. And obviously as liens, they have to be paid from the closing. But our statutes state that if you have a penalty or a fine, same thing, penalty or fine, you leave your garbage can out after 5 o'clock and next thing you know, you owe the HOA $50. Those types of things are not liens, and they only become liens when they're reduced to a judgment. Do you guys have something similar to that in Michigan when it comes to HOAs? Because the HOAs here, what they do is they just dump it all on their payoff statement. And, it could be $3,000 in fines and penalties. And they're like, well, we're not going to agree to allow you to close without those payments. Like, wait a minute, those aren't liens. We don't have to pay those. Do you have something similar in Michigan? And do you see fights with HOAs on those types of issues?
We don't see it much here, but we are very similar to you. So, I mean, fortunately, we don't get a lot of that. In Michigan, it's, again, a little off topic, but we get blight for the city of Detroit, and that's generally, but the exact same rules apply. Just because it's on there, it's not a lien. So only if it's the current owner, they require us to pay that, where if it's any of the previous owners, we can disregard. So unless it's been recorded as a lien. So yeah, but very, very similar to the HOA.
And then one last question, I'll turn it back over to Andy. Cure notices. Does the standard, well, in Arizona, we use the Arizona Association of Realtors contract for any transaction involving a realtor, right? And that's kind of the standard form, and realtors won't deviate from that. And that has a 3-day cure notice. I think that's pretty standard. So I don't know if, there's associations in Michigan that have, their forms, and if you see the cure notice. But I actually recommend for my investor clients, especially if they're wholesaling, to have like a 10-day cure notice. What are you seeing in Michigan as it relates to cure notices?
10 to 15 days generally.
Yeah.
And I don't know how your recording works in Arizona, but in Michigan, we send the deed from the closing table, and our counties a lot of times are weeks or months behind in recording, so there's a huge gap period that we're ensuring
Oh,
over. So, a lot of times, we allow more
mhm.
they allow more time to cure just because we're waiting for things to get caught up.
Yeah. So Arizona, we do have a gap period that title companies are concerned about, but it's actually before closing. So all of our counties, I believe in Arizona, are all e-recording. And so you record, and especially a title company, they get confirmation within, a matter of hours. Our firm we can e-record, but we're not a title company. And so we don't have we're lower on the priority, list, if you will. And so they take a little longer to do ours within 24 hours. Um, they normally either say we accept or reject the document. And if they accept, then they give us a recording number. But title companies, I mean, they record, and they receive that recording number in a matter of hours.
That would be delightful if we
Yeah,
had that here, where we
right.
e-record, but not all of our counties e-record. And
Yeah.
yeah, sometimes we're waiting weeks, if not months, to get some of it back. So
Right. Now, where we have the gap that title companies are worried about here in Arizona is there's an indexing period. So just because I record doesn't mean that the county has then indexed it. They've looked at the
mm,
document, said everything looks right. You have your right exemptions for, assessor's purposes, and you have the right grantor, grantee, all of that good stuff, and looks good. And so they accept the document as meeting their, recording requirements, but they don't index it. And so what happens is a it takes a couple of weeks to index. And so you have basically, from the date of closing back 14 days, you have title companies that, um, you know, run the risk of something recorded within that 14-day period that wasn't properly indexed. And even when they do their final, title search the day of closing, it may not pull something up within that 14-day period because of the indexing delay. And so because of that, they run that type of risk, and it's just a risk that they run, type of thing. But yeah, so we have that risk, but it's on the front end and not, following the
yeah,
actual close of escrow.
yeah, always fun, right?
Yeah,
Yeah.
always fun.
Erica, I want to ask you, going back to the purchase contract itself and just kind of compare what we see here in Arizona and what you see in Michigan. It's not uncommon with real estate investors here to enter into a purchase contract, and then during the escrow period, in order to lock up or stop a seller from potentially selling it to somebody else or canceling the deal, whatever else, they'll record a memorandum, basically a memorandum of the purchase contract. And here, if you don't have express authorization in the purchase contract itself, even be able to do that, essentially give somebody the ability to record some interest as a matter of public record, it's a real problem. It's essentially against the law, and of course can create title issues and so on and so forth. Do you have that a similar practice amongst real estate investors in Michigan, and can those create title problems in the closing?
Sure. So here it's a claim of interest that they can record once they have their purchase agreement. It's nice that they have a clause in their PA, but it's not mandatory here, to my knowledge. But there are problems. A couple years ago, there was somebody that had just went and filed a whole bunch of them, and then when the title company would call and say, "Hey, you have a claim of interest on it. How do we get this removed? We need to release your interest." He would say, "Well, give me $1,000, give me $1,200 because it's cheaper and faster than taking them to court to try to get it done." So people were paying him, and he was finally caught and prosecuted. But it does happen. So yeah, it can certainly cause problems.
I want to talk another type of transaction, pretty common here in Arizona for real estate investors, but the practice of assignments, assigning a contract during the course of escrow. Do you see that a lot in Michigan? And what kind of issues do you run into in having problems to close with assignments?
Sure. So we do these every day. So being an investor friendly title company, this is certainly a way for them to avoid um, having to truly double close, right? And bring all the fees. And then there's double closing fees and transfer tax twice and owner's policies twice. So the assignment is a great way for investors to do that. And that way they never take title either. So their risk is lower. So it's a great thing. But we see problems when investors aren't forthcoming, or they're not letting the seller know that they're not the ones buying it. There's problems with that. We also see issues when the the wholesaler, that the assigner, is working with a private seller and sells to a buyer with a realtor, because the realtor needs to see both the buyer and seller's settlement to get paid. So when the investor isn't upfront about fees or assignment fees or things that are getting paid, or if the end buyer is getting a lender, an assignment fee is not generally something that is an approved fee on the buyer side. So we run into issues with that. So it's really knowing your product and being open with the buyer and the seller about your intentions, and that maybe you aren't the one that's going to buy it and you may sell it to somebody else. Because as a title company, when people call us and they ask us questions, we don't know what you told your buyers and sellers. So we can't, it's hard for us. We don't want to cause a problem or cause the deal to die. But it's a risk that you take when you're not upfront with your clients. So.
Erica, to follow up on that, as far as the assignments and lending and that type of thing, do you see in Michigan, it's kind of a newer type of transaction, but it like novations?
Yes. So
Oh, okay.
just recently, probably in the last, 6 to 9 months, we started seeing those come across our desk.
Right. To me, those seem to alleviate some of those issues. As far as I mean, now you have to, you probably need more disclosure to the seller in those, but it alleviates maybe some of the issues on the back end, right? As far as the types of fees that are being paid, lender issues, commission issues, those types of things. And we can talk about novations a little bit more if we have time, and some things that maybe you guys want to see from a title perspective in there. But keeping with the assignments, I know we have problems out here with multiple assignees and not really knowing who's closing. Have you seen that? And what are some suggestions to resolve that?
Oh, I wish I had a solution for that. I would
Yeah.
probably, make a couple extra dollars for that. Yeah, I think our worst one was 8. It was assigned 8 times. Um, and half the people didn't know the other half of like, it was a mess, trying to figure out, because a lot of them put EMDs in. So we had, I think, 5 EMDs on that one from the different people. And yeah, it was definitely a challenge. And who wants their fees wired? Who wants their fees in a check? And who are we paying? And where is it going? And um, it definitely gets complicated. I don't know why it needed to change hands that many times, but um, and in those cases too, I mean, I understand that the seller signs a purchase agreement saying that that's okay, and they're getting what they get paid as long as they close on time and for the amount they agree to. But it also gets a little crazy when those assignment fees pile on like that. So
Yeah.
my question always too, like to that end buyer, usually the owner's policy is only for the amount of the original purchase price. So if it's a $50,000 deal and it ends up being a $90,000 purchase price, generally that $40,000 assignment fee isn't accounted for the owner's policy. So it's still only a $50,000 owner's policy. So they only have coverage for the 50,000. So that's always a risk too when that end buyer's not getting that full amount of coverage.
That's very interesting. That's the first time that I've heard anybody in this investor space bring that up. That's that's a problem potentially for that in
Right.
buyer. Is there a solution to that? I mean, can they purchase or obtain extra coverage?
They can,
Okay.
as long as. So, I mean, obviously, if it's $100,000 property, you can't get $1 million in coverage. So you have to have some kind of gauge to how much that property is actually worth at the time, not what it's going to be worth once it's rehabbed, but worth at the time. So if you can justify the price through, comps or an appraisal, or then sure, as long as it's reasonable, we can insure it for that extra coverage. But I don't think most people think about that. So if they're paying $90,000 and there's a claim, they only have 50,000 in coverage. That hopefully that never comes to fruition for them. But if it does, that they're stuck with a $50,000 policy.
So an assignee may actually, that in buyer may want to think about putting in the assignment a provision that the assignor pays for the difference in coverage out of
Sure.
the assignment fee. Why not? I mean,
Yep.
you're asking that in buyer to take that risk, to take the assignment, pay more for the property, and yet not receive the same coverage that they,
Right.
normal buyer would receive. Oh, very interesting.
Or deal with the contingency where the property's not worth the same amount anymore, right?
Right.
And have options to if the right to cancel or whatever else had continued, but yeah, very interesting.
So one thing that some of my clients have done, some of my investor clients who, regularly, they're wholesalers, they assign, but they've had transactions like what you're describing with 8, and they're like, it's just a disaster. We don't want to do this anymore. And so what they've had me do, which would solve the problem, although it may limit your pool of assignees, is put in the assignment that it can't be further assigned without approval from the original assignor, and that way you've basically stopped it there. Now, at least here in Arizona, this investor space surprisingly is competitive on one side, but it's also very collaborative on the other. And so you have all these meetups and groups and uh, social media groups where everyone is sharing ideas and helping each other out. And so, just because you have that in there doesn't mean that, the
Right.
assignor is going to say no. It just basically says, hey, I want to know who you're assigning it to. I want to make sure we're going to close this transaction. I want some input on, who this end buyer is going to be, which, makes sense. What about, and here's another thing that we've come up against, is, so we talked about the cure period in the purchase contract, right? The 10 to 15 days that, you're seeing in the purchase contracts. So you end up, you've assigned the contract, or the wholesaler or the original buyers assigned the contract, and you end up at the original closing date, and that assignee is not prepared to close, right?
Mm-hmm.
And the original buyer, the wholesaler, is like, well, I want to find somebody else, or I want to close it. I mean, this is a great deal. I'll close it. And so then we look at the contract and we're like, well, you can't because you've assigned it, which means you've also assigned the cure right. Have you seen that? And have you seen where, maybe they've tried to put some contractual language in an assignment to, resolve that issue?
No, I haven't seen any additional language. I've seen them do an addendum to fix or negotiate or extend or revoke, that everyone agrees to. But we had one that the other day where as- the assignee was not ready and signed all of our papers, and we didn't get any money. And 2 days later, we still didn't have any money. So they ended up doing a release and he had a backup assignee, but they were still before closing date, so their contract was still valid. So for him to move forward, they had to have it released. We weren't sure if they were going to release it or not. So um, you got to be I guess, I mean, that's certainly something to think about is, when you assign the contract, you're assigning your rights to that contract. So absolutely.
Yeah, unless you carve out an exception, you're assigning
Hmm.
your full bundle of rights, which includes your right to receive a cure notice. And you're telling that end buyer, you have a right to receive the cure notice. And, my hands are tied, type of thing. So,
Hmm.
um, very interesting.
Erika, let's talk about double escrows. We see a good bit of those. What do you see with your real estate investors, double escrows, and what kind of pitfalls are you seeing that get in the way of closing?
So when we do double closings in Michigan, you used to be able to use the end buyer's funds to fund the entire transaction. That can no longer happen in Michigan. So each transaction has to fund independently, which is why the assignment is such a great product for the investor clients. They don't have to come up with that money. Um, but in generally, we only see people double close when that spread is so large that they don't want to disclose to the seller, um, that they're going to assign it, or they don't want the buyer to know how large of an assignment fee they're actually getting. So that's really the only time we see those double closings. Um, and not a lot of pitfalls except for the fact that you're paying transfer tax twice. You're paying for two owners policies, two closing fees, two closers, wire fees. So I mean that spread has to be uh, large enough for it to make sense. So the people that are getting a $3,000 assignment fee, a double closing really isn't going to make sense. Um, or if you're borrowing the money like a transactional funding, you got to add that additional fee in. So, most people, unless it's a nice spread, we don't see them doing double closings. So those aren't as prevalent anymore. That the assignment has certainly taken over.
Erica, I want to talk about the transactional lender for a minute, because
Sure.
like you said, it used to be that you could use the money from one escrow, fund the other, and, it was all good. You closed same day or within, minutes of each other.
Hmm.
And obviously that's no more. And that's kind of a trend throughout the country. And so a lot of our clients that we represent are transactional lenders. Some of them are actually providing like earnest money loans, but others are doing the more traditional um, transaction funding for double escrows. And of course, they're wanting to protect themselves, right? Because the biggest concern or risk is I'm not a buyer. I'm not taking an interest in this property, yet I'm shelling out all the money to close this thing. And what happens when the second escrow fails to close for some reason, right? So what are some things that like a transactional lender can do, whether that's escrow instructions, taking a promissory note, deed of trust, et cetera. But what are some practical things that like a transactional lender can do to protect their interests in, both transactions?
So just as you said, so most of them either have one or two things going. One is they have a deed and a mortgage, or I'm sorry, a note and a mortgage in their package that they have signed. And if it doesn't close, we have our closing instructions to record that. Um, the other is they provide closing instructions that say, do not disperse until the B2C transaction, all the docs are signed and you have the money from the end buyer. Then you can disperse. If not, funds are to be returned to me within 24 hours. So, depending on what their closing instructions are, is how we, proceed. Because sometimes that transactional funding, you can do the closings back to back. Sometimes people are in different states, so it's borrowing money for a couple days, for transactional funding. So depending, I mean, and the price goes up. So the longer these people keep that transactional money, which is expensive, um, the more money it's going to cost out of their assignment fee or their closing fees, their profit at the end of the day. So, but yeah, those are the two ways that we see that happen. Um, I actually, if you don't mind, I kind of wanted to comment on your deed in lieu of foreclosure discussion that you started with.
Yeah,
Um,
absolutely.
the other thing that I have seen is when the deal is being done with the private lender, the hard money lender, there is an escrow agreement instructing an attorney or a title company to have them sign a quit claim deed at the time of closing and having it held in escrow. And then upon proving that they did not, that way they can avoid the foreclosure process altogether. That was another one that I've seen. Have you seen that in Arizona as well?
Yeah, the quote unquote performance deed.
Yeah, there you go.
Yeah, we've seen that. You know, I
It
once
makes me
again,
nervous because
it
how
makes
do
me
you
very nervous.
prove? Because
Yeah.
they're saying that
It-
they didn't pay. So how do you prove that they did pay? It's one of
Right.
those. It, it's a little unnerving for me, but I've definitely seen that happen, especially when it's like a short term loan or it's like an
Mhm.
interest only loan or if there's no payments due for 6 or 12 or 18 months where they're like fine, you don't have to make any payments, but you sign this and we hold it, and if you don't pay me back within the 12 or 18 months we just take it back. So it's a little unnerving. It's not my favorite by any means, but I've seen that happen as well. But people don't want to go through the foreclosure process, and in Michigan, you give notice. It goes for sheriff sale, and then if it's occupied property, it's a 12-month period. So people don't want to wait that long. So if it's vacant, you can get it turned. But generally in Michigan, it's 6 to 12 months. So 6 months for regular residential, 12 months if there's acreage or farmland involved. Um, but you might be waiting a long time.
Yeah, and I've never had it challenged, but um and I'm not a huge proponent of the performance deed or delivering a quick claim deed like that for a number of reasons. One is what I talked about earlier, which is you go and record that quick claim deed and you've not gone through the foreclosure process. So if there's mechanics liens, if there's because
Sure.
a lot of times these investors are buying it to improve the property. And so now you have contractors working out there with who may have mechanics lien rights. And so you have mechanics liens and uh, you know, HOA liens and other liens that are out there that crop up that you then record that quitclaim deed. Well, you're taking it subject to those liens, number one. Um, Number two, like you pointed out, there's some unscrupulous lenders out there who see the market tanking and, oh, we got this quitclaim deed here. We want out of this loan. Boom, we'll just go and record it instead of going through the standard, foreclosure process uh, and waiting for even a default, right? Maybe the
Hmm.
borrower is making their payments, but the lender's like, I'm not secured anymore. Boom, I'm going to record the quitclaim deed. Um, so that's the second thing. And now that might be able to be resolved if you deposit the quitclaim deed with a servicer who's only authorized to record it if payments are missed and that type of thing, or maybe an attorney or something like that. But you have that. And then the third thing I question is its enforceability, meaning, like you said, in Michigan and the same in Arizona, there's very specific statutes as far as uh, going through the foreclosure process and time periods that you have to wait and reinstatement rights and payoff rights, or right to receive a payoff and pay off before the sale. And then this will be kind of a segue into, our next type of transaction. But, we also have, if you don't want to do your traditional note, we're a deed of trust state, but it sounds like Michigan's a mortgage, your note
Mortgage,
and
yep.
mortgage, or note and deed of trust. If you don't want to do that, then you can do an agreement for sale. But even in Arizona, and I'm sure it's the same in Michigan, we can talk about it, but in Arizona, we have very specific procedures in place for what an agreement for sale looks like. And, if you want to execute or cause a forfeiture in that type of transaction, there are time periods depending on the amounts that have been paid and that whole thing. And even, whether you can do a non-judicial or judicial forfeiture depends on whether you have a servicing agent or you're making payments directly to the seller. So I'll turn it over to Andy and we can talk a little bit more about, agreements for sale. But, in Arizona, those are the statutory means of basically engaging in a, lending transaction related to real estate. And none of them provide for escrowing a quitclaim deed. So
Right.
I
Right.
wonder what it looks like from an enforceability perspective.
Yeah. So, Erica, I know that maybe no profession or no two professions are more focused on changing market conditions in the real estate market than title officers and maybe uh, uh, brokers. But as the market changes, the type of transactions tend to change. And thinking back, 10 plus years ago during the last big real estate recession, I did a lot of seller carryback type transactions. Clients would hire me because they couldn't get the conventional financing, so they'd come up with some sort of unique deal. And we started to do a lot of in Arizona, they're either called agreements for sale or land installment contracts, which is where the legal title by deed is not conveyed the conventional way like it normally is. It's held and equitable titles transferred, and you just make a payment. And the attraction was depending on how much was paid on the loan, if there was a default, relatively quick or a relatively easier way to obtain title back to the property. Um, Does Michigan have a kind of an equivalent concept to the agreement for sale? And are you seeing more of those? And what kind of problems do you see in closing those transactions?
So just to clarify, so we've seen a few things. So one, we call them the land contract. So I don't know if that's,
I think that's the
um,
same thing. Yeah.
yeah, okay. I just want to make sure that we were on the same page. Lingo across the country differs a little bit.
Sure.
So we see that a lot. So the only issues come in, it seems, if there are still current mortgages on the property. Um, Sometimes the seller pays them off, sometimes they don't. So we take exception to those on the title policy. Generally, the seller still is the one making those payments. The buyer pays the seller makes the payments. Um, but if the buyer wants to pay it off early, sometimes we've seen the seller not have the funds to finish paying that off at the time that the buyer's ready to pay it off. So we've seen that become an issue. We also have seen issues where during the time of the land contract, if the seller has any federal or state tax liens that come up, those attached to the property. So again, when it's time to pay off and we run that title search and we find that more is owed than what the buyer has to pay the seller. So we've run into that a couple times.
In Michigan, in land installment contracts or land contracts, who who holds the deed during the or legal title to the property during the course of paying off the loan?
So for a land contract, the seller still keeps it in their name. Um, so it
Do they typically retain, um, servicing companies to do that or have it held in title? Or is it just all left with the seller?
it's generally all left with the seller. We have investors that buy notes, and those people that are doing an exorbitant amount of contract that they do hire a servicing company. Uh, but generally, it's just an agreement between the buyer and the seller, and the buyer makes payments to the seller. The deed is held in escrow either at the title company or with an attorney. I always tell them do it with an attorney with that title company isn't around in 10 years or whenever that land contract gets paid off. You just don't know what's going to happen. Um, but yeah, we see land contracts coming quite often. I also have a lot of clientele where, if they maybe if the buyers can't afford it or their credit or their employment history or something like that, we do see investors that will buy it for them, and the, the seller, whoever buys it, is on deed. The buyer makes those what we record what we call a memorandum of land contract. So the seller can't just sell it to somebody else. There's a memorandum of land contract recorded that says the seller owns it subject to the interest of the buyer. So that way, very much like a mortgage or a deed of trust, um, all the information isn't on there. Like the note has all that personal information, so the memorandum has very little information, but it's enough to record saying that the buyer has interest. So it protects them from the seller. If the seller passes, if something happens, if it goes into foreclosure, it's something that says that buyer has interest in the property to protect them.
Slightly off topic, but I'm just interested to kind of gauge different markets. But given the increase in mortgage interest rates, maybe it hasn't happened enough yet, but has there been, as far as you can tell, an appreciable increase in the amount of seller carryback transactions that you're seeing?
Yes, they are. My staff groans a little bit, especially when it's like a subject to transaction, just because of all the additional paperwork. But we've seen a lot more seller financing type deals that are coming across our desk right now. And maybe that has something to do with the interest rate. Maybe it has something to do with just the lack of inventory. So buyers are offering more money to sellers, or the sellers, right now with the market, actually, some of the pricing's going down a little bit. So some of the sellers are actually getting scared, thinking that if they don't sell now, they're not going to see numbers like this again for a while. So they're getting creative on their deals, especially if the property needs a little bit of work. So
Yeah. Let's talk about option agreements. What kind of problems do you run into in closing agreements where there is an option?
just we don't see those a whole lot. They're just not super common. So it's just like a purchase with like an option to buy. Is that what you're
Yeah.
referring to? So um, it seems that many investors, the intention is good, but a lot of times, like those never end up finishing out. So that option, they end up optioning it out quite often. So I don't know if you see that in Arizona, but a lot of times that when they do an option to buy, a lot of times that buyer falls out. So the seller seems to redo those often, but we don't see them a whole lot across our desks right now, at least not in the area that I'm in Michigan.
And that brings up a good point of what we see a lot here in Arizona, which is parties entering into option contracts, recording a memorandum of the option or recording the option itself, and then not having clear objective termination provisions in the option. And now, like, the optionee didn't perform or isn't going to perform, but they've disappeared, or maybe they're just unwilling to release the option, even though maybe they've breached because it was a lease and performance type thing. Do you see that as well, like clouds on title because of these options that are recorded, and all of a sudden now you're trying to close to another buyer and you have this old option out there and you guys are uncomfortable closing?
So in Michigan, like especially with those land contracts, they do where they almost have to go through like an eviction process through our court system. So that's depending right now too with COVID being over and the all of the evictions that were postponed, a lot of our court systems are certainly backed up. So people that need something like that to clear title, it's taking much longer to get that through the court, so we can get our notice of writ or eviction, so we can move forward.
Erika, this has been unbelievable information. We appreciate you taking the time with us to talk about these issues. Tell our listeners where they can find you.
Oh, my name is Erika Weichel. You can find me at Michigan Investment Title, www.mititle.com.
And do you have a presence on social media? I know you've got Facebook, Twitter.
Facebook is the best way to get a hold of me. I'm not as cool as everybody else with, with Instagram. I just started an Instagram, so Facebook, I'll respond. I know how to do that one.
Well, welcome to the Uncool Club. You're in good company.
Thank you.
All right. Well, thanks so much for being with us, Erika. It's been great. Look forward to doing it again with you.
That sounds great. Thanks for having me.
All right, everybody. That is our show for today. Next week, make sure to be with us. Do unique real estate deals require unique closing strategies? With us, we've got Carrie Sparks and Cynthia Turris from WFG Title. We'll see you guys next week.
Have a good day, everyone.